NEC, if we can move on to the next slide, please, Jen, and the next one. Yeah, over the last few years, we've seen a tendency for substantial amendments to both NEC 3 and 4. So if we can move to the next slide, please, Jen. So this is what we're going to look at. First of all, I'm going to touch on the kinds of changes that we're seeing generally. So all I can see now is me. I can't see the slide. Lovely. So this is the programme, and I'm going to, first of all, after we've looked at what we're looking at today on the agenda, I'm going to sort of look at what kind of changes we're looking at generally. But these changes, they're all right by reference to the clause numbers. And they sort of fall into a few categories. So if you look about halfway down, we've got clause 50 payment. So that's all about typically changing timescales and really sort of making typically payments longer in duration to be made. So that's benefiting the employer, and then we've got things like clause 17 ambiguities and 19.1 prevention. So they are things where ordinarily under NEC contractor would expect and is entitled to make a claim, so is entitled to a CE, a compensation event. But the typical changes we see shift that risk to make it more difficult for the contractor to make the CE claim, or move the risk completely to the contractor, so the contractor has no ability to make a claim. And then the other category of changes that we have is things like clause 21, the contractor's design. So this is a mixture of the CE point that I've just referred to, but more than that, it's potentially about changing the risk in that the contractor's design potentially becomes more onerous, and therefore any defects that might need remedying then become the contractor's liability where they might not previously have been. So if we can move to the next slide, please, Jen. So just a reminder of what Z clauses are, and this follows on from my theme of huge numbers of changes that we're seeing at the moment. They are referred to in contract data part 1, so that's the second bullet point, and the quote is actually the third and fourth bullet points. So it says Z clauses additional conditions of contract. And then it goes on to say, if option Z is used, the additional conditions of contract are, and the idea is that those additional conditions are inserted. So what I would say is here, the emphasis is on additional. The aim or the intention of NEC wasn't that we would be changing the risk. It was that we might, in very specific projects, have to have additional conditions of contract in addition to the ones in NEC. Now, clearly, if you're familiar with NEC contracts, you will know that that isn't in reality what happens. But I think it's useful to bear that in mind, particularly if you are negotiating and there are substantial amendments to the contract. So if we can have the next slide, please. So yeah, initially in the 1990s when NEC came out, there were, basically there were no amendments, no Z clauses. Then we went through a period where there were Z clauses, but there were genuine additional clauses. And the typical ones you would see would be things like, you know, contractor agreeing to comply with the anti-bribery and corruption legislation that we have. Also the contractor agreeing to confidentiality clauses. So fairly benign clauses, ones that, you know, you wouldn't really, as a contractor or a subcontractor, you know, be too bothered about agreeing to. What we've seen, I would say probably in the last 10 years, is a move towards far more extensive amendments. So changing the risk profile. So typically moving the risk or more risk onto the contractor. And also changing the mechanisms within the NEC, and we'll see examples of both of those as we go through. The next slide, please. Okay, so getting into the detail of the changes that we tend to see. So NEC 3, we have provisions with regard to ambiguities and inconsistencies, and NEC 4, it's referred to as requirements for instructions, albeit it's all the same thing. So in essence, this clause, so it's clause 17, it says on the slide. Yeah, clause 17, but it works in conjunction, and you'll see the 1, 2, 3, 4, 5th bullet point down with the compensation event at 60.11. So the standard NEC basically states, clause 17, that if an ambiguity or inconsistency is found within any of the contract documents, then contractor, once it's been identified, refers it to the PM, and the PM states how it's to be changed. Then the provisions, so 60.11 means that it will be a change to the scope potentially, and then 63.10 deals with how the value is to be assessed of the compensation event. So it's effectively saying that ambiguities and inconsistencies within the contract are the client's, the employer's risk. So the change you tend to see is a complete 360-degree turnaround, so that it becomes the contractor's risk. So any ambiguity or inconsistency within the contract is the contractor's risk to remedy, but the PM still gets to say how it's remedied. So my impression is that lots of contractors, subcontractors look at this and sort of think, well, you know, how many ambiguities, inconsistencies can there be within a contract? It can't be a huge risk, so we will take it. You know, we will be responsible for it. My experience is that this is quite a common occurrence. So ambiguity or inconsistency, it can be it can happen in several ways. So you could have a scope of work or the works information. Page 2, it might say something. Page 23, it might say something else that directly conflicts. So you've got there an ambiguity or a discrepancy. It might not be as clear as, you know, one says contractor does X and the other says the contractor doesn't do X. It might be a bit more subtle than that. But the upshot is, you know, there is an ambiguity in the contract. So first of all, it requires the works information, the scope, to be really carefully reviewed if the contractor is going to take the risk of ambiguities or inconsistencies. The other occasion that it might occur is not so between different documents within the contract. So, for example, there might be an ambiguity between what the contract, what the NEC says, or what the Z clauses say, and either maybe what the contract data says or what the scope says, etc., etc. So that's the sort of thing we're looking at. So in my experience, those ambiguities are most commonly in regard to the scope of the works information, ambiguities within them, or quite often between the contract data, parts 1 or parts 2, and or the scope, and the contract data, and possibly Z clauses or the NEC clauses. So there is quite a wide scope for there being ambiguities or inconsistencies. And as I was saying, my experience is I've had quite a lot of disputes where this occurs. So, my advice to contractors, subcontractors and consultants is, don't be too keen to take on this risk, because, it does have the potential, particularly if, for example, you don't have a chance to review the scope in a huge amount of detail, possibly because there isn't a great deal of time to submit the tender price. And also, where you get ambiguities between the different documents within the contract, it's sometimes because, one person has prepared one document, another person has prepared another, and, so there's no one person reviewing all of the documents to ensure consistency. So if we can move on to the next slide, please. Okay, so the next one, very similar to the previous one. So this is clause 19 of NEC 3 and 4. By the way, I'm not looking at earlier NEC contracts because I'd be really surprised if anybody's still working on them. So prevention is effectively what you may know as force majeure. So it's something that happens. So it's got to be something where neither party has caused it. So COVID is a good example of this. Neither party has caused it, didn't cause the pandemic. And, neither party was aware of it at the time of contracting. So this was only useful in that kind of COVID period right at the start. So for contracts that had been entered into, before probably March, February 2020. After March 2020, when we went into the lockdowns, of course, when people were signing up to contracts, they were aware of COVID. So that's what it's about. Unlike the ambiguities and discrepancies, I must say, even as a lawyer, I'd stopped talking about prevention force majeure because it just never seemed to happen in real life. And then, of course, we've had a few incidents recently with, COVID, the Suez issue, and also the war against Ukraine, and various other things that have happened since, unfortunately. So basically, this clause, again, as with the other clause, it works in conjunction with a compensation event. So the compensation event is 60.119. Now, what we're seeing here is a sort of one type of Z clause which just removes the right to make any kind of claim. So to say that the contractor bears all of this risk. Probably more often we're seeing the clause watered down in terms of the contractor's right to claim. So extra criteria being put in, so it makes a claim more difficult, and or trying to sort of carve up the claim slightly differently. So perhaps saying that contractor might be entitled to an extension of time, but no financial impact would follow if there's an act of prevention. So again, just be careful of this. As I've already said, I've kind of spent 10 years doing seminars and saying, well, we never come across force majeure matters. And, then all of a sudden we see quite a few. I just saw a question there about natural disasters. And yes, arguably it would cover it. Sometimes they're easier to claim than others. So you know, the fundamental has got to be that it's something that has happened through the contract that has impacted on the time or financial impact, financial cost of the project, but that neither party would have been aware of at the time of contracting, and neither party has caused. So in theory, a natural disaster would, you know, come within that criteria. So tick the boxes for the criteria, but, you know, then don't forget that for any claim, there's also the criteria of showing that the extra cost, the extra time has been caused by that event. So, you know, geographically, if there's a natural disaster somewhere else, and this was the difficulty with the COVID claims at the time, because it was difficult to specifically say what had caused the problem, because of course we had Brexit, which we did know about, happening in the background, etc. And of course the contractor does also have a responsibility if something happens to make sourcing materials from one area more difficult, more expensive, incurs delay. You know, the contractor's got to take steps to see if they can find those materials elsewhere. So next slide, please. Okay, so design, primarily fitness for purpose, which hopefully everybody knows. You know, this is, you know, comes with, you know, red flashing lights to avoid. For design, the normal standard of care is reasonable skill and care. Fitness for purpose is a higher standard. It's not covered by the professional indemnity insurers, so there won't be insurance cover for it. So the point here is that typically you would use X15, which means that the standard of care is reasonable skill and care. So that's good. But you need to be careful, particularly in any Z clauses and in the scope, that there isn't anything that looks like a fitness for purpose clause, despite the fact that X15 applies. Because just going back to our discussion about ambiguities, that is one area where it might be an ambiguity if you've got X15, reasonable skill and care, and then a Z clause or the scope saying that it's fitness for purpose, or saying something more subtle to the effect that, you know, this facility has got to work in the way that we expect it works. It's got to perform to specifications. So just, you know, just look out for things like that, because, you know, you don't want to, you know, risk sacrificing your X15 because you've got a higher standard somewhere else. Next slide, please. Okay, so very briefly, I just want to talk about intellectual property rights. So this is protecting the contractor and their design and their ability to use the intellectual property relating to their design, you know, generally moving forward. So the key points here are that, first of all, the first bullet point is that the contractor gives, and it says, an irrevocable, royalty-free and non-terminable license. The key there is license. So you're giving somebody a license to use the copyright. You are the intellectual property. You are not giving them the copyright as such. It's a little bit by analogy. You give someone a license to use your house. It doesn't mean that you've given them your house. You've not given it away. They're just allowed to use it. And then the other point to note here is, what can they use the license for? So this is the fourth bullet point down, and so it means yeah, so they can reproduce it for usually, I mean, the key is they can use it and reproduce it for all sorts of things relating to the works that the contractor has constructed. The two key ones that are usually up for argument are using that design to build something else. That's a no. It shouldn't be included. The one that sometimes gets through is allowing the copyright to build an extension to the facility that the contractor is building, which, you know, ordinarily would be a no, but sometimes there's some ground for movement on that. So if we can just have the next slide, please. Okay, assignment is about transferring a right from one party to another. So usually we're talking about the assignment of the contract in this case. So there are no provisions in NEC3, so typically we see them included. Similar provisions are included in JCT, in the Schedule of Amendments, and typically it allows the the client stroke employer to assign the contract, but it prevents the contractor from doing so, or it might let the contractor assign, but, you know, on limited occasions. From the contractor's perspective, the only risk here with regard to assignment is in some situations, if the contractor were to sell the business or want to sell the benefit of the contracts to somebody else for them to have the benefit from the contracts, you couldn't do that if the assignment was prohibited. And it's difficult to argue against it, because, you know, if you're a client and you're picking a particular specific contractor to do your work, you don't want to find that partway through the work the contract's been assigned and somebody else is doing it. Next slide, please. Okay, so instructions to stop work. So this relates to clause 34.1, where the PM stroke client have the right to stop stroke suspend work either before it's actually started or after it's started. And as you would expect, so this is the second bullet point, clause 60.14 says that it's a compensation event if that happens, which makes sense. But there is a trend for saying, for a Z clause to change all of these clauses to say either it isn't a compensation event, it's the contractor's risk, so no compensation event for it, no extension of time, no costs recovered by the contractor, or to water it down in some way. So just be careful about this. Next slide, please. Okay, so payment provisions and programs. So 50.3 in NEC3, 50.5 in NEC4 allow the client to deduct a quarter of the price if the contractor doesn't submit the first programme within the timescales in the contract data. So that's standard NEC. What we see is that being amended, so it's very clear that that is to be deducted if the contractor hasn't submitted the programme. We've seen it amended to refer to a situation where the contractor hasn't submitted the programme and where it has submitted the programme, but it hasn't been accepted by the project manager. So basically that penalty applies if the project manager doesn't accept the programme. that means that the project manager can just reject the programme continually throughout the project, and contractor then faces a 25% deduction on every certified payment. So the only way to remedy that would be to start an adjudication and get a determination as to whether the project manager has properly rejected that programme or not. But that's not what NEC intends. The other thing that we've seen is the right to do to make the deduction if interim subsequent programmes which are provided throughout the project aren't provided by the contractor, either where they're not provided, a deduction is made, percentage, similar to the clauses that we've looked at, or even where the programmes are submitted but the project manager rejects them. I've seen clauses that says deductions can be made there, so just be really careful about that. So moving on to clause 51, payment timescales, and that just says it to be reviewed on a project specific basis. Typically the timescales for payment will be extended, so just be careful about that. In terms of clause 53.3, so that's NEC 3, and 54.4 under NEC 4, this only applies to options C and D of the contract. This change arises out of some recent case law, because these contracts, these are the pain gain sharing contracts, which basically provide that the contractor through the course of the project is paid on the basis of the schedule of cost components plus fee percentage. So it's the actual cost basically, plus the fee percentage. Paid that all the way through the project until completion. And at completion, whatever has been paid is checked against the target figure in this pain gain option CD contract to see whether the project's in pain or in gain. If it's in pain, then the chances are, depending on what the contract says as to how that pain element is to be split between the parties, the chances are the contractor might be paying money back to the client. And as you can imagine, sometimes in projects, it's very apparent that it's gone into a pain situation and is going to end up in a pain situation before completion. Now, the standard NEC says that that assessment of what the contract has been paid as against the target, and therefore the payment of the pain amount or the gain amount should be made at completion. So that's what this clause says. When the case went to court, the court affirmed that. It's pretty clear wording. So what we're seeing now in options C and D is clients changing it so that pain gain can be assessed on a more regular interval. Now, it may be, because it works both ways, if through the project it's in gain throughout the project on each assessment, then money is being paid to the contractor as it goes along to represent the sums they would be due. It's just a problem for the contractor if the project's in pain, because inevitably it will either have to repay money or that money will be reduced in its interim payment application. So it's just something to be aware of, to understand, and make an informed decision on when you have an option C or D contract. Next slide, please. Okay, so changes to compensation events. So the first sort of principle of NEC is that if you have a compensation event, you are entitled to both time, so an extension of time if the project has been delayed, and you're also entitled to all your financial consequences. So that includes the extra cost for doing that work, if it's extra work, but also the cost for the extra time that you were on site. So it's sort of a compensation event incorporates all the elements of JCT. So the element that allows you to be paid for changes, stroke variations, the extension of time provisions in JCT, and the loss and expense provisions, which cover the cost of the time. Now, if you're familiar with JCT, you will know that there's a long list of items that allow a contractor to claim and be entitled to an extension of time. But for the loss and expense, some of those items entitle a contractor to an extension of time, to loss and expense, but not all of them. So effectively, there are some items, take for example weather. Bad weather, sufficiently bad weather, might get a contractor an extension of time, but no right to any loss and expense. So no right to the sort of prelims costs for that extra time on site. NEC is different because time and money is paid. But what we're seeing more and more for some compensation events, and some of them are listed in that second bullet point, is a mechanism where there's a Z clause which says for these particular compensation events, all the contractor is entitled to is an extension of time. It does not get any money relating to the time. So just be careful with that. I can see why clients might think that's fair because it's following JCT, but of course, you know, this isn't a JCT contract, it's NEC. It's a slightly different type of work in that it's more kind of engineering based work, but also if you come to other seminars, you'll know that the compensation events in NEC are quite specific. It's more difficult for a contractor to prove that they come within the criteria for a compensation event under NEC than it is for JCT. And that's because for NEC, it's always linked to somebody, the contractor having to prove that the client or the PM or somebody employed by the client hasn't done something that is specifically stated they were or were not to do within the contract documents. So usually it's within the scope of the programme. So you've got to have that piece of paper in the contract that says, you know, client needs, client needs access to the site on these days and they require them on different days. You've got to prove that, so it's more difficult to prove. Whereas JCT is wider and vaguer, so it tends to say things like, you know, if the employer doesn't do something, it could reasonably be expected to have done within a reasonable period. So it leaves a wider ambit for claims. So JCT claims wider ambit, but you don't necessarily get your loss and expense for all of them. NEC narrow ambit, but you get your extension of time and your money relating to that time. So, you know, just be careful of that and, you know, bear in mind the fact that it's not just as simple as saying, well, this is just following JCT. Next slide, please. Also, so another reason why, you know, that situation shouldn't just be accepted because it's JCT, so we'll import it into NEC, is that we have some quite harsh time limits under NEC for notifying compensation events. So that's clause 61.3. I'm sure you know about this. So the contractor has 8 weeks from becoming aware of a compensation event to notify it. It's less, I think it's 7 weeks in a subcontract. And, you know, this is what I call a killer clause, because if what the contract says is that if the contractor doesn't notify within that timescale, then it loses its right to a remedy. It doesn't get any time, it doesn't get any money. Now, the similar clauses in JCT aren't quite as harsh. So again, another reason for not, you know, changing the way the compensation events are compensated, as we've just been looking at. Also bear in mind, in terms of Z clauses, what you might expect to see is that 8 weeks being cut by 2 weeks. So commonly it's 6 weeks to notify. Also quite commonly 4 weeks. You might want to push back on that simply because these are such onerous clauses if you don't comply. And of course, the benefit of having a standard form contract is so that people know and understand that contract and know how to operate it. So if you are changing key deadlines via Z clauses, it makes operating the contract more difficult, and it sort of begs the question as to why the timescale is reduced. It just creates that extra risk that if the contractor doesn't have a proper kind of handover to the site team, somebody in, you know, the person from the site who is meant to notify CEs might not read the Z clauses properly, might miss the fact that the time's been reduced. And of course, you know, on a big project, the chances are different people will come in to cover for holidays. You know, people might leave, new people might come onto the project. And, you know, again, it's just all risk, extra risk of missing the fact that the timescale has been reduced. The second kind of key bullet point here, the PM time bars. So there's 3 clauses, 61.4, 62.6 and 64.4. What we tend to see is these provisions simply deleted so that they do not apply. So just by way of reminder, what these clauses are the contractor's ability to push the project manager into complying with the timescales and requirements in the compensation event process. So 61.4, by way of example, is the project manager's obligation to, oh no, I think actually it's 62.6 is the project manager's obligation to, once they have received a quote for a compensation event, to either notify the contractor that it's accepted, rejected, being assessed by the PM, or is to be sort of revamped by the contractor. PM has a time limit to do that. This barring clause comes in if the PM misses that deadline. The clause allows the contractor to send the PM a reminder and to give the PM 2 more weeks to do it. And in the quote example, if the PM still misses that new 2-week deadline, so their second chance, then they're deemed to have accepted the quote, and the client has to pay the contractor for it, even if they really, you know, are not happy with the amount claimed or the time claimed. So these are important provisions for the contractor to maintain the progress of the CEs. Now, what I would say to contractors is these aren't the worst Z clauses to accept, because you might not have that mechanism, so you lose the opportunity to get, you know, the quote and the provisions deemed to have been agreed by the PM. But what you can do if those clauses aren't there is bearing in mind that if the PM hasn't responded to the notification within the timescale in the contract, then if we go back to our fundamentals of contract law, the PM hasn't complied with the contract. So the PM is in breach of contract, and we have a compensation event that is breach of contract. So, if I was a contractor wanting to progress the contract and the PM hasn't responded, those clauses have been deleted. I'd just serve an early warning notice and then a CE notice to say, PM's in breach of contract. Probably not going to be any money attached to it, but I would imagine that the PM would quickly respond once that's been issued. Next slide, please. Yeah, so this is just the point that we dealt with earlier about ambiguities, and what you will see when you're reviewing your Z clauses is that, we'll see that clause 17 would be amended, and also the compensation event provisions with regard to ambiguities. This one in particular states that if the PM gives an instruction to change the scope to resolve an ambiguity or inconsistency, then it's basically the cost and the time, the CE, that results is assessed in favour of the party who didn't provide the scope. So usually it would be in favour of the contractor. Sometimes that's changed, so it puts more risk on the contractor. Sometimes it's deleted if that clause 17 puts the risk of ambiguity in the contractor's court for obvious reasons. Next slide, please. Okay, so concurrent delay. Now, you might think, so concurrent delay are two delays to a project happening at the same time. And you might think, oh, well, that would be really unusual, but it is amazing how often that actually happens. So again, this is another amendment, another Z clause that we're tending to see as a result of a fairly recent case called North Midland Building and Sidon Homes. It's 2017 case. So I'm pretty sure that this was a JCT contract, but there was a clause in it that was similar wording to the kind of third bullet point, the second sub-bullet point. And the court was asked to determine what effect that had. So the clause said something like any delay caused by a compensation event which is concurrent with another delay for which the contractor is responsible shall not be taken into account. So what it's saying there is that you've got two delays going on at the same time. One is a compensation event, so it might be clients changed the scope, it might be really extreme weather, might be something to do with the ground conditions, and then another delay that's the contractor's risk. So, it's all happening, in the new year, and none of the contractor's personnel turn up to site, all poorly, all, feeling that they can't really face coming into work after, having had such a wonderful Christmas and New Year. But they're two delays and they're different. They're caused by, or the responsibility for them is the different parties in the contract. So the key bit was where it says not be taken into account, because this is saying that for the compensation event, you ignore any delay where it's concurrent in this scenario. So it's effectively saying it's the contractor's risk if there are concurrent delays and the contractor's responsible for one or both of them. Now, this was to get around the position in JCT where if you're entitled to an extension of time, didn't matter if there was concurrent delay, you got your extension of time. So similar clauses we're seeing in NEC. So again, just be aware of what it means and the impact that it might have. And if we can have the next slide, please. Yeah, I think we can move on to the next slide because that's not a major Z clause. Okay, so this one again relates to NEC case law, but this is more a Z clause that the contractor might like to consider. Now, I appreciate it's really difficult for contractors to get specific Z clauses included, but you might find that employers' clients are amenable to this one. So it relates to this clause 83.1. So it's the first bullet point, and it says that each party must indemnify the other against all claims, proceedings, costs, etc., due to an event which is the other's risk. Sorry, that's completely wrong. See, the party indemnifying is indemnifying if it's their risk. You're not indemnifying somebody for other risk. Sorry, that's a typo. So what happened? So this was the case of SSE, Generation and Hockteeth. And what happened here was it was an NEC contract. The facts of the case state SSE engaged Hockteeth. So Hockteeth was doing the design and construction of a hydroelectric scheme in Scotland. It had to take out a joint names policy, and part of the works involved the construction of a tunnel by Hockteeth, which collapsed after completion. So a claim was made under the policy, but in the meantime, SSE brought court proceedings against Hockteeth. Hockteeth said, as you would expect, to the court, can't bring a claim against us because we have joint names insurance. The court looked at this clause 83.1, and particularly because it was badged as an indemnity clause, which is a sort of super compensation clause, said no, that clause says each party indemnifies the other, where something has happened that is their risk. So something that's happened which is Hockteeth's risk, they've got to indemnify SSE for. So in an ideal scenario, a contractor would want something including here. So a Z clause saying that this clause doesn't apply where there's joint names insurance or there's insurance cover in regard to the matter, because it sort of seems a bit academic to start pursuing a party directly if there is insurance cover for it. Next slide, please. Okay, so some additional clauses that aren't specific amendments to existing NEC clauses. So the first one is you will typically see in both JCT and NEC a clause that says that the contractor can't use or specify certain materials. So they're unsafe materials that aren't used for construction. So just be careful about the wording of that clause. Another obligation might be about third-party agreements. So these third-party agreements are typically agreements that the client has entered into with third parties. And the typical clause will say, firstly, so this is a Z clause that says contractor has had sight of these agreements. Sometimes the contractor hasn't had sight of them, but the purpose of the clause saying it is so that the contractor cannot argue that they haven't had sight. So if you're going to sign up to this clause, you need to ask to see these agreements. So the typical clause will say the contractor's had sight of these agreements and agrees to compensate the client if the contractor puts the client in breach of any of these agreements. So hopefully you can see why you shouldn't sign up to that if you haven't seen the agreements. The other point is that if you then receive the agreements before you've signed the contract, obviously, sometimes there might be really, really long detailed agreements. So you might want to say to the client, well, actually, the clause should say which clauses of these agreements, we are not to put you in breach of. We can't review all of them. So just be careful about that, and also consider whether, it's really necessary for you to sign up to the clause at all. Collateral warranties, so these would be dealt with at optional clause 8. And you might want to consider, capping the number of warranties that are provided, or limiting the list of beneficiaries. Not a major issue. Professional indemnity insurance, I think the key thing there is run it past your insurers to make sure that your policy complies with the requirements in the contract. My experience of PII is that they're always willing to check that. And then finally, the termination provisions in NEC and JCT, to be fair, are often amended to reduce the compensation that the client will pay in the event of a termination. So a particular example of this is the termination at will provisions in NEC. So in NEC 3, it's at clause 90.2, one of the core clauses. In NEC 4, it's at optional clause X11. And the compensation package includes being paid the fee percentage. So that's at clause, it says on the second half of this chart, clause 93.2, and it's the reference at capital A4. So basically it means that if contractor is terminated and has done £500,000 worth of work on a £1 million project, it still has £500,000 of work to do. So that's £500,000 that it should have done, and obviously part of that would be overhead and profit. So this provision allows the contractor to recover its fee percentage with regard to the balance, the unpaid balance for the work it hasn't done. So if you haven't done £500,000 worth of work and your fee percentage is 10%, you would get £50,000 as compensation for that, as well as other things. That is a common one to be removed. And again, I think with termination at will, it's not appropriate because it's not a scenario where the contractor's done anything wrong. Termination at will is used where the client just decides for their own reasons that they don't want to proceed with the works. And in fact, it could be that they've found a third party to do it cheaper, but it's their choice. It's not a termination down to the fact that the contractor's not doing a good job or something like that. So just be careful about that. Next slide, please. Yeah, I think this is the last one. So yeah, looking at the X clauses, we've got X1, obviously, X1 is about being paid for inflation increases. Up until recently, it's rarely been used. It's still not used massively in my experience, but long-term contracts in particular should really have some form of inflation provisions. The X2 changes to the law and statute requirements. So if this applies, any changes to the law and statutory requirements become a compensation event if they are brought in after the contract's signed. Therefore, contractor would be entitled to any time or money that compliance involves it in. Changes might include limiting that CE to applying only if the changes to the law or changes to the statutory requirements that come into force are those that couldn't have been reasonably foreseen. X15, reasonable skill and care, we've already touched on that. Great if it's included, it should be if it's a design, but be careful in the scope, in the Z clauses, to make sure there's nothing that sort of contradicts it and indicates that part of the works, have to work at to be fit for their purpose, or, work in accordance with the specification. And then finally, X18, really nice limitation of liability clause, is often heavily amended in the Z clauses. I mean, to the extent that I once saw it included, and then when I looked at the Z clause, I realised that it had been converted into a clause that limited the client's liability rather than limiting the contractor's liability. But putting that aside, what we often see is there is a limitation on the contractor's liability, but there are a vast number of things that do not apply to that limitation. So it might be that, contractor's liability is for 6 years only and capped at £10 million, but neither of those apply if it's covered by insurance, doesn't apply to delay damages, and doesn't fraud. If there's a fraudulent claim, it doesn't apply. So there's a whole list of carve-outs from that cap. Some of them, so the fraudulent one, you can think, well, that's valid, but the list kind of tends to be so long now that you look and think, well, is that a valuable cap in any event? What kind of claims can come that aren't carved out of that cap? So I think, so if we can have the next slide, please, Jen, I think